Thanks for being with us today, and thanks for sticking with us for this panel. You won't regret it. It's an incredible panel. Bruce has also done something different this year. He's made this panel via his newsletter free to anyone who receives his newsletter on the Securities Docket newsletter. So going to be very good. It's all about the SEC, very timely. Let's get to the introductions and get to the substance very quickly. So talk about living in the eye of the hurricane. Our moderator today is Kristina Littman, and she did so 24/7, be it crypto, data breach, privacy, whatever the tech. As the first and former chief of the SEC Division of Enforcement's Cyber Crypto Unit from 2019 to 2022, she has a hefty track record of fighting valiantly to stop some of the worst high-tech frauds in history. Now she is co-chair of Willkie's Digital Works practice and a member of the Securities Litigation and Enforcement Practice Group. At the SEC, Kristy enjoyed a stellar reputation as a tough but fair law enforcement official and regulator who fought to protect investors above else. And now her clients get the benefit of counsel who is both respected and admired by all who worked with her and those who battled against her. Kristy Littman is the IR equivalent of Michonne from The Walking Dead and Olivia Benson from Law and Order. And if Kristy had a theme song, it would have to be Stand Back by Stevie Nicks, because that's what her adversaries do when Kristy walks into a conference room or a courtroom. Welcome, Kristy.
Thanks, John. You're the absolute best hype man there is.
Next up is Nicole Friedlander, who is thankfully returning back to the IR Forum Masterclass. Nicole is the co-head of cybersecurity practice at Sullivan and Cromwell. She came to Sullivan and Cromwell from the Southern District of New York, where she served as chief of the Complex Frauds and Cybercrime Unit. So we have two former chiefs on this panel. Her cybersecurity experience includes leading the successful indictment of Iranian state-sponsored attacks on 46 financial institutions and the prosecution of a Russian national for hacking U.S. banks in a case that the FBI made one of its top 10 of the year. To me, the Southern District of New York prosecutors are a very elite and special groups. They're the elite of the elite. And I can't wait to hear Nicole's thoughts on the latest regulations, which I'm sure she has observed from both sides of the coin. Nicole is the Sarah Connor of IR. Remember Sarah Connor from the Terminator? And if Nicole had a theme song, it would be The Nights the Lights Went Out in Georgia, because that song is all about getting the right lawyer, which is why Nicole is always the first call when a client is in deep trouble. Welcome, Nicole.
Thank you for having me. I'm going to update my bio immediately after this.
Next up, we have Luke Tenery, and I'll get to in a minute. We have Jorge Tenreiro. So it's a little confusing. I think we'll just stick with Luke and Jorge because Luke, they're very different. Luke Tenery is a partner with the global consulting firm StoneTurn and a veteran of the IR Forum Masterclass. His bio will tell you that what makes Luke a cyber expert is not just his 20 years of experience helping mammoth organizations mitigate complex cybersecurity data privacy and data protection risks, but you might miss the fact that Luke is also certified as a chief enforcement security officer, a chief information security officer from Carnegie Mellon and a certified network penetration tester. And that enables him to manage the investigation of a data security incident and also fix it afterwards. And that not just with better tech, but better governance, which is the key. So like a board member who can instantly step in and become CEO, Luke has been known to step in as acting CISO amid an incident response and the quintessential expert to have in the foxhole defending it against an attack. He's a multi-talented cyber veteran. He's the Clint Eastwood of IR. And if Luke had a theme song, it would have to be the anthem Lean On Me from Bill Withers, because that's precisely what Luke's clients do. So welcome, Luke.
Thanks so much, John. Really appreciate that.
Sure. And finally, we have Jorge Tenreiro. Our next speaker, he's perhaps the most prolific SEC enforcement attorney in the history of the SEC Enforcement Division. Find an SEC case involving cyber or crypto, and his name is somewhere on the pleading. Jorge Tenreiro, the deputy chief of the Crypto Asset and Cyber Unit in the Enforcement Division, is really a very special guest today. I can honestly attest that I have read every complaint, every brief, every speech. Yes, he also writes speeches for the SEC chair, and every other court filing or statement that Jorge has written. And they are masterpieces. They really are very different than any SEC pleading you'll have ever read. He presents the style of a street fighter who could also be poet laureate. And like so many SEC Enforcement Division lawyers, Jorge walks the walk and he talks the talk. all along the way, he is 100% fearless. And look up the definition of public servant in the dictionary, and you will find a photo of Jorge Tenreiro, because that's how he rolls. He is the Bruce Springsteen of SEC enforcement and the Stevie Van Zandt of cybersecurity and digital assets. And because Jorge is nothing less than a Cromwell fuel-injected stepping out over the line, if he had a theme song, it would have to be Born to Run. So welcome, Jorge. I can't wait to hear this panel. I'll turn it over to you, Kristy.
Thanks, John. Those I think that you might have topped every other year with those intros. That was fantastic. Thank you so much. So we'll get right into it. I think, as John suggests, Jorge is going to be the star of the show here. I think all eyes are on the SEC these days with respect to cybersecurity, and particularly enforcement of the new rules. So I think we'll start there. We are going to touch later in the panel on DFS out of New York and some DHS matters as well. But starting with the SEC, last year in July, the SEC finalized its kind of long anticipated cyber rules for public issuers. Those rules introduced a new item 105 under the Form 8K, which requires registrants to disclose any cybersecurity incidents that they determine to be material, and to describe the material aspects of the incident, including nature, scope, and timing. And that has to be done within 4 days of that materiality determination. The rule also imposed new reporting requirements in periodic filings for processes for assessing and identifying and managing material risks relating to cybersecurity, and then additional disclosure requirements about board oversight of those threats and of management's role and expertise in dealing with cybersecurity threats. So the rule it's relatively new. We're going to talk also later about SolarWinds, which was filed before the rule. But getting to the rule, Jorge, can you just kind of start by giving us a sense of what enforcement's perspective is with respect to, how you're looking to enforce these new rules? What types of incidents and cases are you looking at to make sure that these new requirements are being implemented?
Sure. Thank you, Kristy, and thank you, John, for that introduction. My remarks are obviously my own in my capacity as Deputy Chief of our unit, do not necessarily reflect the views of other members of the staff, commissioners, or the commission. So I think, with respect to this new rule and with respect to, I hope, everything that I do at least, we focus a lot, I think, on victims, and we understand, obviously, that when there are cyber attacks on publicly traded companies and other market participants, the company is a victim, but we also consider the investing public to be a potential victim of these incidents. And so I think, the focus here is, from our perspective, the decisions about disclosure directly impact customers whose PII or financial information might have been compromised. And decisions about that may also be material to investors in these companies. And so I think we want to ensure that market participants are doing their part to prevent and respond to cyber incidents. But really the goal of the focus is to prevent additional victimization by ensuring that investors receive timely and accurate required disclosures. So, we're looking at firms to make, in the public company context, the principle here, I think, is that registrants need to regularly review and update all relevant cybersecurity policies to keep up with constantly evolving threats. For example, what worked 12 months ago probably isn't going to work today. I think we're focusing on making sure that the right information goes up the chain to make the required disclosures. If you don't get the information right, it doesn't matter how robust your disclosure policies are. So that's something that we're looking at. And then I think finally, I think maybe not the most important thing, but an important thing as well, is that we're going to have zero tolerance for gamesmanship around the disclosure decision. So instances where people are more concerned about reputational damage than about coming clean with shareholders, companies working hard to persuade themselves that disclosure is not necessary, based on hyper-technical readings of the rules, or minimizing the cyber incident. So those are the sort of situations that attract our attention historically, and that will, presumably attract our attention in this context as well.
Thanks, Jorge. I mean, that's a little bit of a warning you just issued, which I hope I look, from my perspective, and I'm sure Nicole and Luke's as well. we are always telling clients that they don't want to be the example that the SEC wants to make with the new requirements. One kind of follow-up I had, that historically, I think when we've seen, in some ways, these new rules are not that different from the way the SEC has always enforced the rules, right? Like, if you had a material incident, it needed to be disclosed before. These are more prescriptive. The requirements in the periodic reports are also a little more prescriptive, talking about risk disclosures around governance, and assessing risk. Historically, though, when we've seen a charge out of the SEC that focuses on one of those risk disclosures in like a 10Q or 10K, it has been tied to an incident, right? The company, I think in Yahoo and Facebook are good examples where the company had an incident, and then we looked back at their risk disclosures, and they had kind of talked about the risk as though it was hypothetical at a time when management knew that the incident had actually already occurred. But with these new rules that really are quite prescriptive about what needs to be in these periodic disclosures, should we expect to see standalone cases, or is it going to be more of kind of like looking back at those disclosures and seeing whether they were really consistent with what management knew to be the case at the time?
I think it's a little too soon to say what can we expect to see. I mean, I think, first of all, you're quite right, that, the rules, I guess one of the thoughts behind the rules, right, as the adopt and release explained, was that a lot of companies already provide this information on different timelines, the different levels of details, different sections of filings. So, one idea, of course, was to make these disclosures more timely and consistent. Regulation by enforcement is a phrase we hear a lot in another context of my life. I think when you have rules, you do have to enforce them. But I think it's a little too soon to tell whether it's going to be, standalone or in connection with something like that. I mean, I think it's the first year of a rule is very important, as the staff themselves sort of work to understand how people are responding to it. And, I think CorpFin staff is working with public companies. So I think it's too soon to specifically tell you whether you can expect one or the other, but I think you can certainly expect that we take the rule just as seriously as we take all the other rules that the commission has, and that, we'll be making sure that people have the right incentives to comply with them.
Thanks, Jorge. Luke, I want to turn to you for a moment. These are obviously disclosure-based rules. The idea is that the SEC governs disclosure, not the actual underlying cybersecurity program. But if you're a public issuer and you have to now start making disclosures about your risk assessments and risk management, you're going to do the work to improve them so that your disclosures are accurate, and what your investors want to hear. Can you talk a little bit about the work that you're doing with issuers to implement, some of the programs that underlie these disclosure requirements?
Sure. Thanks, Christy. I can appreciate some of the comments that Jorge mentioned, and just in terms of, I'll just say, issue-specific dynamics from a SEC perspective, but even more holistically, and we'll talk about probably a couple other government regs, but tend to appreciate it in multiple lights, just given how I interact sometimes with the CISO organization or the security organization, that integration point with counsel, sometimes outside counsel, pre or post incident. But I think firms, issuers included, are still dealing with and grappling with and coming to terms in many cases, this kind of whole of government approach. That's not my term, has kind of been talked about. And then the dimensions over the last couple of years that the SEC first guidance and then rulemaking has sort of driven. I would say, organizations are in kind of two broad categories, particularly as it relates to the SEC, in some cases, other regulators. One, they're looking to ensure that they got the review of certain incidents right, perhaps even in hindsight for prior incidents. And then going forward, organizations, executive levels, sometimes boards, sometimes driven by the compliance or legal teams, want to make sure that we have just the right posture and working mechanisms with the security function. So if and when some of these incidents do occur, we have right levels of communication, we have right levels of awareness. But what's more, as I think in prior conversations, Kristy, you and I had, there's elements too of just like the SEC or other regulators interested in dynamics around just what the ongoing cyber risk management program looks like. Yes, portions of that probably will include hygiene or understanding, at least from a hindsight perspective, if there were the right mechanisms to ensure timely and accuracy disclosures, both from the security function relating with other aspects of the business. But then just from the risk management side, how well did our cyber program align with assets and threats and some of the typicals? And we see common threads too across other areas of the regulatory landscape. But I can't really say too much new, but again, we'll talk about this with other regulators. The definitions around material are obviously of interest. A new one sort of in the proposed dynamic, which we may talk about later, is substantial incident coming from DHS and CISA. So these complexities, again, speak to the minimization of some of the and potentially avoidance issues that organizations need to think about, and shifting more towards a greater model of transparency, which is, I think, is in totality one of the greater drivers behind this. And so common themes across other regulators, similar with SEC in terms of that enhanced transparency, and then expectations for the firm to know what happened in an incident, with broad understanding across the firm, not just in the CISO or legal, and consistency of communications across that. But firms, again, are looking to be more precise and have awareness to ensure that the right levels of transparency on incidents and so forth, or risk management, are going to the different regulators and dealing with some of those complexities.
Thanks, Luke. And Nicole, I want to get your take on this. I think, I mentioned earlier that a lot of what we see in the new rules is similar to how the SEC was enforcing the rules before. But, I'd like to hear from you about whether you've seen a shift among your clients in terms of the way that they're approaching cyber disclosure in general.
Oh, absolutely. A very big shift. First, a lot of positive response. I know there's been a lot of criticism publicly, and the SEC had to address many, comment letters and the like. But there's been a positive response in the sense that these are rules, right? It's not. You get criticism as a regulator if you're perceived to be, regulating by enforcement. And here there was clearly a very significant effort to come up with rules that companies can use as guideposts as they try to think about what to disclose. So positive reaction there. Companies are smartly taking a close look at their disclosure controls and procedures to make sure that their incident response processes and plans provide for the timely escalation of potentially material incidents. It's many public companies, all the companies I work with now have, since the rules have taken a really conscious, focused, careful look at their policies. So that's a good thing. A challenge is for companies to define and understand what's material or potentially material in the cyber context. We all as lawyers know it's not just quantitative, it's qualitative. The SEC and the new rules makes clear the materiality standards haven't changed. But in reality, most current events that public companies deal with involve quantitative impact. And when it's qualitative impact, it's pretty clear what that qualitative impact is at the time that the event is occurring. Cyber is different. It is very rare for there to be a quantitative impact, at least right away. If there is one, it is from, typically like a litigation or enforcement action that it comes way down the road. And so they don't have typically that metric to use in assessing potential materiality. For qualitative impact, that can be really hard too. Reputational impact can be very hard to assess in real time. And I would say that since the SEC's Pearson action, where the agency found an incident material that involved the compromise of a large quantity of PII of school children, it's been particularly hard to assess materiality. Companies have asked, what is it about that case? What is it about the PII of children per se that makes a compromise of that data more significant than the compromise of any other, of an adult's, PII? Actually, usually think of an adult's personal information as being more sensitive because adults are the ones with credit cards, adults are the ones with bank accounts. And so since the Pearson action, materiality has been challenging. And I would say now that companies are taking a hard look at their escalation procedures, there are a lot of questions about what materiality means. And I think what we're seeing, and I'll be really interested in the panelists' take on this, but I think we are seeing some uncertainty about what should be disclosed. And as a result, we've all seen a number of 8Ks in which companies disclose incidents that they say they don't believe are material. And I think that's, at least in part, a reflection of the uncertainty as to what materiality really means here. And people just don't want to get on the wrong side of the SEC. So interested in others' thoughts on that.
Yeah, I think we will stick with the materiality discussion. I agree, Nicole. It's kind of what I think my clients struggle with the most. The reality is most issuers are having some sort of cyber incident all the time, right? They're stopping a lot of them. And so trying to figure out where that line is between something that's really, frankly, routine today and an incident that's going to be material for investors, it can be challenging. And I think the worry is always that it will be assessed later with hindsight that they don't have at the time that they're trying to feel their way through these determinations. Jorge, can you maybe spend a little time kind of talking about what you think best practices are for issuers when they're thinking through those materiality determinations?
Sure, and I'm very glad to hear Nicole, talk about what public companies are doing in terms of thoughtful and mindful and all these, good reviews. I mean, that's a good thing, right? Those are the good practices that you want, and I think part of that process presumably will also include part of those policy procedures. Presumably, also include sort of ways to figure out the answer to that question. And I don't think the point here is to sort of do something with hindsight or a gotcha sort of situation. I mean, in the adopting release, so the rule, materiality is a touchstone of securities laws, and the new rule limited the disclosure obligation to material cybersecurity incidents, I think precisely for the reason you identified, Kristy, which is that companies face these incidents on a daily, if not more frequent basis. So I think that, in the adopting release, the Commission affirmed the materiality standard that companies should apply is the same one that the Supreme Court has articulated in the cases that we all know and love as lawyers, like Basic versus Levinson, and cases that have followed it, as well as in Commission rules about materiality, right? Like in the, so those rules are going to be and will continue to be the guiding principles for these materiality assessments. So, the Commission declined to adopt a new standard for materiality unique to cybersecurity. And I think, using this time-tested standard rather than a new bespoke standard is consistent with the overarching rationale for the rule, which is to give investors disclosures to help assess risks to their investments in the same way that they receive consistent and comparable disclosures about other risks that public companies face. So it's not meant to be anything. It's the same materiality standard, and it's the same sort of analysis. There's no doubt that, people acting in good faith can interpret rules and reach conclusions. And, I think having you, the lawyers, that are working with these companies are probably best positioned to understand, and hopefully you have a good understanding of the incident and the sort of totality of the circumstances, so that you make that determination in good faith. And I think talking to the staff of Division of Corporation Finance might be helpful in this context as well. I mean, I can see that as being challenging for them. They're not in the company. They don't have all the facts that you do, but they do have an open door policy, and they are, I think, encouraging people again, as I noted, the first year of the rule is always a very important year as for the staff themselves to think about how this rule is playing out in context. And so with this materiality standard situation is particularly for some reason, something that you're getting stuck on, I'm sure they'll want to hear about it.
Thanks, Jorge. That may be hard to sell to clients, but we'll see. On that note, I want to talk a little bit about a recent enforcement action that's gotten a lot of attention. This is the SolarWinds case, of course, which was filed before the new rules were adopted. But again, it's kind of the more typical disclosure regime and the allegations that there was a botched disclosure there or failure to disclose a risk. Nicole, can you maybe talk a little bit about some of the concerns you're hearing? I imagine there are a lot of concerns among your clients and the industry in general.
Yeah, there really have been. They fall into a few buckets. Maybe two I would highlight for this group are with respect to the allegations about SolarWinds risk factor disclosures and general questions about the SEC's role and enforcement power with respect to cybersecurity. So, and then I would say the third would really be the decision to charge the CISO. But as to risk factors, so just for folks who aren't familiar with the issue in the case, the company disclosed 4 paragraphs worth of cybersecurity risk factors, quite a lot of information about the serious cybersecurity risks that the company understood itself to face. The SEC in its complaint alleged that those were not, specific enough, or they were too generic in the SEC's view in light of the known risks that the company faced. But it's really unclear for companies why the SEC believes that, because the risk factors are quite detailed and long, and they disclose very serious risks. So questions there. Companies now, this is all perspective, right? They have to look at their risk factors and say, what is it we ought to be disclosing? And so, I was talking before about how helpful it is to have guidance from the SEC, and this one is challenging because it's unclear from this action what guidance to give companies about their risk factor disclosures. The second issue, the role of the SEC. So the complaint makes many allegations about the company's cybersecurity and alleged deficiencies, and claims that these deficiencies were, material. But, cyber experts have, many of them have different views than the SEC, at least as the SEC has described the issues in the complaint. The complaint, identifies certain deficiencies, but doesn't address whether, for example, the company had compensating controls, which, is a critical question you ask in cyber cases. Most public companies that have robust cyber defenses assume that any one layer is going to fail, or even multiple layers of defenses will fail. And the question when they're trying to assess whether they're well protected is whether they have compensating controls. And so the bottom line of all of this is that companies are asking, isn't the SEC really acting here like an all-purpose cyber regulator? And companies are concerned that they could face a claim that they violated the federal securities laws, where they simply have deficiencies in their cybersecurity program. I know that's not the SEC's view, but I can tell you as a practitioner, it's hard to explain. It's not easy to explain, why companies are, if they're not right about that concern, why that is. So, not to put Jorge on the spot, but I'll be interested to hear his views on that. The third issue is the decision to charge the CISO. And I would just observe that, CISOs are the ones fighting the battle more than anybody. It's often, they have to they face the pressures of the business, right? The business wants to get products to market. It needs to move quickly. It has to make technology easier to use. And so the CISOs are the ones sort of leading the battle internally. And there's been, I would say the industry's been disappointed. You probably saw there was an amicus brief filed in the case on behalf of CISOs and other professionals who feel that they're being unfairly unfairly targeted. I don't know if that's an issue for Jorge or not, but or you, Kristy, but that's a concern that we're hearing from clients. And the question is whether CISOs will be disincentivized to take these jobs, whether you're going to push really good people away. So I'll stop talking. Those are the main concerns though.
Thanks, Nicole. No, that's really helpful. I think it's helpful for folks listening to hear what others are grappling with. And I'll say, I'm going to turn to Jorge in just a moment, but in response to one question you posed, I have twice now heard Gurbir Graywell, the director of enforcement, say on different panels that in the kind of historic struggle that CISOs may have had to get the attention of management and potentially funding for their endeavors, that this should help them, right? So I think maybe his view is that the CISO should be thanking him. But Jorge, I know, look, this is pending litigation. Nicole referenced some of the recent filings, so I'm almost certain you can't comment on it. But I do think it's probably worth discussing generally how clients or how issuers, clients us, should be approaching the assessment of material risks in their cyber security, their risk disclosures and their filings, because I do spend a lot of time with clients working around, what language that may have historically been framed purely as hypothetical and thinking through how it should be framed given the current circumstances of the company. Can you talk a little bit about specifically the risk disclosures that go in periodic filings and how folks should be thinking about that?
Sure. And you're right. I'm sorry, Nicole and Kristy, I cannot talk about, these pending ongoing litigations. Obviously, you raise some interesting questions and make some interesting points about these things. I mean, I'll say in thinking about risk disclosure, I was thinking back on some of the cases I'd worked on, like as a staff attorney over my career at the SEC, and I've been involved in cases where a company failed. I was involved once in a case where a company essentially knew that its products could cause cancer. Let's just say that. I'm going to try to keep it general. I don't mean to single anybody out, but was telling people that the products were safe, and they knew that in fact there were some issues with the products. I don't think that makes the SEC a regulator of those issues. In fact, they have been accused of violating a regulation that was about, it was a state regulation that essentially, I think the purpose of the state regulation was to address climate change. And I don't want to open the whole can of worms on the climate rule because you already have me on the spot on this rule. But the point is like that these disclosure requirements don't make the SEC the regulator, of airlines. If there's an issue with the disclosures about the safety of planes, like that's not what the rules do, right? That's not what the SEC becomes. And so I understand it might be difficult to sort of explain that to a client, but that is in fact, that's the reality on the ground. So in terms of the disclosures, so I mean, the new rule the new rule has two parts, right? The material cybersecurity incidents part, and then it has more than two parts, but two, like sort of what I think of as main buckets, I guess. And then there's, new item 106 under regulation SK, which requires, disclosure about cybersecurity risk management strategy and governance. It's not necessarily tied to incidents. Now, what was not required, right, was that registrants adopt any particular cybersecurity practice or technology, to my point about the SEC is not a regulator of those things. So I think that the final rules focuses more broadly on the company's cybersecurity processes, and it includes a non-exclusive list of disclosure items. So I think that the formulation recognizes that companies will have diverse approaches to cybersecurity based on their particular circumstances, that not every company needs formal policies and procedures, but some of the items you see, right, are processes for assessing, identifying, and managing material risks from cybersecurity threats, a description of the board of directors' oversight of risks from cybersecurity threats, management's role and expertise in assessing these threats. And so those are some of the things that are in the rule that people need to look at it and disclose.
Thanks, Jorge. And we're going to give you a little bit of a breather and talk about New York DFS, who is a cybersecurity regulator, and some of the new rules that they've implemented, although you're only getting a little bit of a rest because I also want to hear about interactions between SEC and DFS. But last November, DFS passed some amendments to their cybersecurity rules, which are quite prescriptive. And many of them have effectiveness dates in April of this year. So I think folks are kind of trying to pull together their operations to make sure they're compliant. You've got large companies that have to have independent audits. They have to monitor access privileges, including blocking commonly used passwords. They need to monitor for anomalous activity. It's very specific: lateral movement, security event alerts, endpoint detection. It's really kind of the list of what is required is long and detailed. There are also governance requirements for CISOs and the board and management, annual certifications, annual reporting, tabletop exercises, things like that. Luke, can you, I mean, these are the early days, right? These are not yet implemented, although obviously DFS already has some cybersecurity rules in effect. But I want to focus specifically on some of the enforcement actions that DFS has brought, and specifically what practically folks can take from those consent orders. I think there's some commonality about remediation that's been undertaken and remediation that DFS has deemed sufficient. Can you talk a little bit about those themes? Because I think it's really helpful for people to understand what in DFS eyes works.
Sure. Yeah, thank you for that. Yeah, there's been a couple that come to mind. One that I'll probably just tune into most specifically has been the one related to First American. They obviously captured the eye of the SEC in certain contexts too, but I'll note that they were fined, I guess right around $1 million, which may not sound terrible to some firms, but significant in the sense of some of the other underlying issues, and that doesn't necessarily speak to having been there working with firms remediate some of the broader impacts reputationally, or what might need to happen within the security organization or other aspects of the business to sort of take corrective measure. And I'll also say certain key themes, which you alluded to, have certain commonality across the regulators too, from a consent order standpoint. And so there are aspects of, influence and awareness across the regulators. You can tell, not just in a remedial or consent order sense, but also in some of the kind of more proactive requirements and general frameworks of reference for good security practices. But I would say from a remediation standpoint, the incident notification component has been significant, in addition to certain timeliness components, which also have different parameters across the regulatory landscape, elements of quality and awareness of some of those notifications vis-a-vis the dynamics of who knew what and when, particularly at the DNO level and even to other areas of management or execution. Just this overarching theme of sort of having greater notification awareness and consistency. And to the prior point, even from an SEC perspective, that there's sort of this element of space called out in policy that ensures all the right components are addressed and on the incident response and ultimately what feeds up to a notification perspective. But in terms of some of the rigor that may not be immediately apparent in some of the consent orders and follow up, they are concerned about there not just be remediating steps being in place, but that they're validated sometimes by it's well thought of, not a gratuitous plug, but by leveraging third parties to validate some of those dynamics. I think that may be part of the story that's not told there. And then in terms of the overall corrective actions, not just from an incident notification perspective, but the broader cyber risk management piece, and or whatever kind of threat or kind of asset category were impacted. So, example could potentially be, at least hypothetical, I didn't work this one, but with First American, it noted a very specific vulnerability on the web application that essentially allowed a user or a hypothetical user to basically traverse in sort of a numeric fashion to the URL and reveal different customer records. In this case, dealing with title and the property closure and purchase standpoint. But there is some specificity and awareness, not even just with DFS, but I would say other regulators have gotten very smart in terms of their awareness of the significance of certain vulnerabilities, what the assets are of that organization. They're very increasingly tech savvy in terms of understanding the DNA of organizations and how aspects of their risk management, incident response relates to some of those assets. And I would just encourage organizations to, not just from a vulnerability management and reporting and maintaining measures of security risk around potential vulnerabilities, but then that they show hygiene around normal course remediation to either vulnerabilities and incidents. Both from a tabletop exercise standpoint that you mentioned, there's also aspects of how well an organization can just apply corrective fixes to highly specific vulnerabilities or kind of higher level organizational issues related to that, and how, you know, firms, as an example, that are heavy tilted towards public facing web applications or customer facing applications, that they have not just hygiene for good proactive security, but elements and capabilities that allow them to remediate quickly. Sometimes that's forensics, but sometimes that's literally how quickly can they execute code, how closely intertwined is the security function with certain aspects of just the security of software development, allusions inherently there too to some of the supply chain concerns more broadly that have been out there with other cases already mentioned. So again, it's become a much more complex animal, and I think especially with some of the sprawl of certain organizations, particularly in an app or technology heavy environment, greater care just needs to be given to integrations of security across the business, where historically I think too much of that was left to the business. I think you're going to see an increased role of security making its way into the business and driving more of the decision making and influence.
Thanks, Luke. I'm glad you brought up First American Financial. It's a good example of a case where you had New York DFS on the scene assessing the cybersecurity program. And then there was a companion SEC case. The SEC case came out a number of years ago, and I think DFS litigated with First American for a few years before they resolved it. But it's a good example where the SEC investigation was focused on disclosure. The DFS investigation was focused on the underlying vulnerability and the company's management of that vulnerability. Jorge, can you talk a little bit about where that overlap is? I mean, how much work is the SEC doing with DFS where you're kind of partnering and dividing responsibility in the same manner?
Yeah, so that case is a good example, Chrissy, I think, which we filed when you were here. I think one of the things we haven't even talked about today is, of course, the parts of the rule that talk about disclosure with DOJ, so to DOJ. So, I mean, I think generally taking a step back from any particular situation, I think, one of the ideas behind the rule is to create and encourage public companies to work with the FBI, CISA, other law enforcement and national security agencies at the earliest possible moment. So that's something that, of course, we hope happens. I think we believe this time of engagement is in the interest of investors and the public. With respect to your question about collaboration, I mean, I think we collaborate with NYDFS on a bunch of stuff that we do, and I don't see this as necessarily any different. I think we will continue to collaborate with other law enforcement partners. Obviously, as you identified, this situation is interesting in a way in that, at DFS and others might be looking at the company as the victim, where we might be looking at the investors as potential or actual victims. So there's obviously that wrinkle to it, but we've been able to cooperate with other law enforcement agencies and navigate that. So I expect we will be able to continue doing so.
Great. So we have just a few minutes left, and I want to make sure we hit the DHS category as well. I'm going to skip to a recent report out of the Cyber Safety Review Board, and ask Nicole to give us an update. The CSRB recently issued a report after its independent review of the summer of 2023 Microsoft Exchange online intrusion, and it had some really specific action items for cloud service providers. And so I think Nicole would be really helpful to hear about some of those action items that are outlined in that report.
Sure, and I agree. They're helpful. They're important. They're directed at cloud service providers, but a number of them are, I think, helpful for all companies. So it's a very good idea for companies to take a look at the recommendations and consider to what extent they can apply to them. There are also disclosure-related issues that came up in that case that are important for companies to consider. So the recommendations, ones that I think are broadly applicable, the recommendations focus on the need for companies to do threat modeling, especially with respect to identity and access management. They focus on the need to maintain sufficient logs so that incidents can be detected and investigated. That can be very expensive to do. So for all companies, it's a weighing of the benefits and the costs in order to determine which, which logs to maintain. But it is a recommendation that comes from out of the report. The Cyber Safety Review Board also makes some recommendations on disclosure that seem kind of easier to make than to implement, particularly for public companies. So the Cyber Safety Review Board recommends that cloud service providers adopt incident and vulnerability disclosure practices to maximize transparency, including to disclose to victims like government agencies sooner. If you're a technology company or a cloud service provider dealing with a vulnerability, if you're a public company, it's very hard to disclose on, to one victim and not to another, even on the grounds that something could have a national security impact. Here, the board also faulted Microsoft for informing the government agencies that during the incident sought personal information of some individuals. But Microsoft apparently said that they couldn't just turn over personal information of others. They would need a warrant or some kind of legal process, and they get faulted in the report for doing that. And I think that really illustrates the challenge companies can face. I'm sure if Microsoft had just handed over a bunch of people's personal information, it would be faulted in the other direction. So the report is a very good read, both for the recommendations it makes and for some of the challenges that I think the situation Microsoft faced illustrates. The last thing I would say for all companies, it's not a recommendation in the report, but Microsoft was faulted for not updating a blog that it issued about the incident that gave rise to the report. After Microsoft apparently learned that some of the information in the blog might not have been entirely accurate. So for all companies, particularly while I have the SEC on the call here, I would, this illustrates the need to continue to evaluate any, blog posts that you make in order to make sure that what you have out there is still accurate.
Thanks, Nicole. And I think Bruce's reappearance tells us we have 1 minute left for the lightning round question, which is just top takeaway piece of advice very quickly for anyone either in advance of or in the midst of dealing with an incident. Jorge, we'll start with you.
Be mindful, and if you have questions, talk to the Corp Fin staff.
Luke.
I would say awareness on materiality or other substantial issues is a big deal. No longer kind of compartmentalizing certain aspects of the security org and the conversation around compliance to these issues. That's going to continue to be a growing pain and stretch opportunity for firms.
And Nicole, last word.
I think in any incident, recognizing from the outset, it's not only a technical issue, and it's important from the outset to get the various stakeholders involved, legal, certainly, the business management, because everyone has different perspectives, and one of the most challenging parts of incident management is getting everyone on the same page and coordinated.
Great. Thank you, everyone, for your incredibly valuable contributions.